Good afternoon, everyone, and thank you for joining us on our Alterna and Aviso Wealth webinar today. My apologies, it's been a long day. I wanted to certainly thank you for taking the time to join us. Today, we're actually looking at the Executor of an Estate webinar, which I think is a very timely and interesting topic of discussion. When we sent the invite for this webinar, we received a number of questions. We received many inquiries and a lot of engagement because this is a very interesting topic. And it's just sort of, I believe, the one in a series of webinars we are doing around this particular topic of estates and executorship and so forth. So I'm very pleased to have Doug Carroll back with us. Doug has spoken on estates previously with our webinars. And just a couple of housekeeping items. We did have a number of questions that came in, and if you have additional questions, feel free to put them through on the chat. Both myself and Doug will receive them, and we will try and get to as many as we can. We did have, I mentioned, a number that we did receive in advance, and I will try and we've allotted some time for them because I know there are some questions that may not get addressed during the webinar, but I trust that many of them will get addressed. So I'll try and monitor those as we move along. The webinar also is being recorded, and so if you have to leave or you could not attend, a replay will be made available. And we also have some supplementary information that we can provide to you post-webinar in terms of executor checklists and information sheets. So with that, why don't we just jump right into it? And I'm going to introduce Doug Carroll. For those of you who have not attended a webinar before, Doug is a tax and estate specialist for Aviso Wealth, and that's a wealth management firm to Alterna and other credit unions across Canada. He previously ran an estate planning law practice and was an advanced case consultant with a life insurer and a mutual fund provider. Doug also holds a business degree and a Master of Law specializing in tax and is qualified as a certified financial planner and a trust and estate practitioner. He's been doing this for 25 years now, supporting our financial advisors, and he writes articles, does individual case consultations, and of course, similar to the webcast we're doing today. And before I hand it over to Doug, I was thinking about this also because I have older parents who, have wills. I am named as their executor, and I have not had to go through this process myself. And so I started thinking about this as, leading up to this webinar, what is my responsibilities as an executor, being named one, what potential risks do I have to, keep an eye out for? And, for those of you that are executors or named executors, or if you're planning to name an executor, hopefully you'll get some additional insights to, all of that relates to, managing an estate. So Doug, with that, I'll hand it over to you, and I'll sit silently until and monitor the questions that do come in, and we'll try and address as many as we can at the end.
Okay. Sean, thanks for the intro there and the anecdote, your own personal anecdote there. When we do this topic, and I've been doing this topic because of my background running law practice and as you mentioned, a couple of decades or so. Quite often what I'll do it in a group when we're in person is I'll say, how many of you have served as an executor? And people would hold up their hands, and how many of you want to do it again? And everybody's hands goes down because it definitely does have a lot of work involved with it, and it's emotional, it's challenging, and it's also very important. So the topic, what we have here as a subtitle is naming one, being one, because as I'm speaking on the topic here, I'll be speaking on it from both sides, whether I say it out loud. As you are thinking about who is the appropriate person to name as your executor from your side of doing that as a testator on a will, and on the other side of it, if you are the person who is, or one of the people who are asked to be executor or find out that you've been an executor, then the comments that I have are on both sides of that. So I'll switch back and forth sometimes here as I'm speaking. And when I say that in terms of who would you name to be your executor, what I'm stepping past is the common situation where you have spouses who will quite often name one another back and forth as their executor, and similarly with their powers of attorney. And then the next stage is, who among my children or those people whom I trust should I name in that role? So I'm not suggesting that you not name your spouse in the normal course, as quite often happens, and look to others, but there will be a second stage consideration of who should step into that role when you don't have that person who is your life partner. And so those are the kinds of thoughts that I'm getting into here. So we've got a few topics that I'll get into, 8 topics that we'll go through. And we'll bring it around full circle. We talk about compensation as an executor. Again, those of you who have done it before will know you earn that compensation that you get in doing the job of acting as an executor. But I'll take you through first the considerations of what kind of characteristics of the person who would be the executor are the things that you want to think about, and then go through the process of naming someone as your executor, and the job itself, what the things are that an executor does. So as Sean mentioned, you can pop questions into the chat function, which I see are already coming in anyhow, and I think that a fair number of them, not looking at them directly, but a fair number of them, as Sean said, we'll probably hit on them as I'm going through the content here, but those that we don't, then we'll fill that in. So the first thing that I like to bring up about acting as an executor is when talking about the candidate characteristics, is this idea that people often feel honored to be asked to act as an executor, and that's great to feel that that someone has asked you to be the executor because they trust you, but being honored is absolutely the last reason why you want to accept the job of acting as executor. Over 20 years ago, I'd had this doing the same topic, different slides perhaps, but same topic talking about acting as an executor. There was a fellow who was one of the guests that day, and he brought up the situation that he was in, where he had lived in another province and had moved back to Ontario 20 years or so prior. A very good friend had asked him to be executor, and he had lost contact with this fellow long prior to the point where we were sitting at this seminar in person, and he'd gotten a call from this fellow's daughter that he was in a coma and wasn't expected to survive. And so there it was. He was honored to be asked, and so he said, yeah, he would do that at that time, but then it was just something that he had no further connection with. So not that you should not be honored, but look at it in a really practical way when you're asked to be the executor. So one of the things is, are you available to do the job? And that might seem kind of a strange thought, because when someone asks you to be their executor, except in really extenuating circumstances where somebody is in a terminal condition through an accident or something that happens, which does happen, most often it is that you are a family member and you are being asked at some point in the future, and it could be years or decades down the road, to be executor. So when I say availability, what I mean is physical availability. If you are someone who has a lot of job responsibilities, a lot of family responsibilities, and physically are in a different place than the person who is asking to be their executor, then that may not be the best thing for you to be doing, is to say, yes, you are going to drop everything, at least for some tight period of time to start, and then at points along the way, and be available to do the things that are necessary to be as acting as the executor. So be conscious that you are going to have a flurry of activity when the person dies, and there'll be continuing contact, assuming that you're going to hire a lawyer or a trust company to work with you. There will be points where, though you've hired them to do work involved with the estate, you will be called upon to be physically available to do things. And not only it's the availability, it's the willingness that you have to do it. Because if you're looking at it as a begrudging thing where, oh, well, my dad asked me to be the executor, I guess I got to do it. If you're going into it on that basis, it could be really challenging, because it's an emotional time, both for you as the person who's doing it and has a lot of job responsibility. If if you're not fully committed or as committed as you possibly can be, then that can make it difficult on you, and it can make it difficult on the other people involved, and it can make it difficult to actually complete the job in an effective way. So be conscious of that, that being willing is something that will assist you in getting the job going and doing the job in a proper way. In terms of the kinds of things that you'll deal with, you don't have to be a lawyer, a tax person, an investment advisor yourself, but you're going to be dealing with the legal issues, tax issues, maybe the investment issues. I'll come to that shortly. But you're going to be dealing with those kinds of things, and so having a knowledge, a capability of dealing with them is helpful. You can engage professionals to assist. As I said, you can hire a lawyer's office, you can hire a trust company to do a fair bit of the activity, but the buck stops with the executor, the person who is named to do the job. Having a personality that where you are diplomatic is important. If you have a situation with, sometimes happens with families, where there are simmering feuds, small and large, that might be going on, that might be suppressed during the course of mom or dad's life. And then when mom and dad are no longer around, then those things could bubble to the top. And so being able to manage the relationships, particularly if you're one of those people who maybe has had that abrasion, it's important that you have a diplomatic character so that you can get through this. You as the executor are not expected to be the referee of arguments with the other people who are related to the estate, the beneficiaries, or just family members overall. But you will be looked to carry out some kind of leadership function. So being diplomatic is quite important. And the last point here is about your own estate planning as executor. The whole point, so I'll switch sides here now. You as the person who's making out your own will and deciding who you're going to name as your executor, what you're trying to do is you're trying to get certainty as to what is going to happen with your estate. And so the person you name as your executor, you want their affairs to be as stable as possible. And so it's not an unreasonable ask of the person who you're going to name as your executor to say, I really would like you to get your affairs in order as well, so that you have a will and power of attorney, so that should you unfortunately become incapacitated or die during the course of the administration of my estate, that there is that kind of fallback, that things will not completely go into a tailspin if that occurs. And in the will anyhow, you do have the ability to name someone as an alternate executor or a co-executor, but still, it's good if the executor has his or her own estate planning in place. The use of lawyer's office or a professional trust company, it may have seemed in the past, so going back a few decades, that was something that only the really wealthy might have used, these kinds of organizations. But these days, the job of being executor and estates overall has gotten more complicated. It's certainly increased in terms of the liability that an executor might be facing if he or she does not fulfill the obligations, and there's costs involved in doing it. There's time costs involved in doing it. So the trade-off of hiring a trust company to do the job is not the same kind of thing that it might have been a few decades ago, where you would look at it and going, wow, that is really costly relative to my estate. These days, it's not all that unusual to engage a trust company. Certainly spouse to spouse, particularly at younger ages, where all the property at a first death between spouses, everything's going to go to the other spouse. There really wouldn't be that much reason to have a trust company involved. But as you go past that step of everything going in one direction between the two people, then things start to get a bit complicated, and still might not be necessary if you have a sole child beneficiary. But as things get broader, then having a trust company might be a good idea. So just keep that in mind. I'll come back to the point about compensation towards the end. This is the one topic that I'm not going to go deeply on this of the 8 that I'm touching on. This is the legal topic. This is the job that an executor has, is what's called a fiduciary duty. A fiduciary is someone who has either has knowledge or power or access, control to documents, to information, to property, and others depend on that person. So the executor is in this role of managing the property in the estate, and the executor actually becomes the legal owner of the deceased's property during the course of the administration of the estate, to then take care of the job and eventually pass the property on according to the will instructions to the people who are the beneficiaries. So the listing that you see here, acting reasonably in good faith, personally, with an even hand, being loyal, these are the kinds of responsibilities that the executor has, where there are stacks and stacks of books, case law, that in the law library, a lot of that still just exists in paper. There are loads of cases that give detail on what is the nature of acting in an even-handed way between beneficiaries. In being loyal, you as the person who is the executor find out about things, information that if you wanted to, maybe you could use that to your own personal benefit, but you can't based on being a fiduciary. So it's very important that the person who is named as the executor is a trustworthy person. And in fact, in Ontario, the technical term for an executor is an estate trustee, because the estate is actually a trust. It is an arrangement where you have a legal owner, the executor, as the estate trustee, who manage the property on behalf of the beneficiaries. And that's what a trust is. It's a breakdown between legal ownership and beneficial ownership, so that you've got someone who's got the capability of managing property, taking care of it, and then transferring it over to the beneficiaries. Or if those beneficiaries are frail or there's a concern about them, perhaps the executor continues on acting as trustee over the property, or subnames another trustee on an ongoing basis. So this setup with an estate is that you have a trust in place, a trust arrangement in place, and the trustee, the estate trustee executor, it has a very important responsibility to take care of the property, always looking at the best interests of the beneficiaries. And there actually is a positive duty to act. When you are named as the executor, you may not, and I'll come to this in just a second, you may not decide to accept the appointment, but once you do, you are responsible to continue to act in that capacity. Again, going back about, 25 years or so ago, I had a situation where someone brought up that she had been named as executor about a year prior, and had started working on the estate, and then it was just so overwhelming that everything got set aside. Well, you can't just set it aside. You've got the responsibility to continue on with the job. And in that case, unfortunately, the markets had gone in the wrong direction with the property that was invested. And so there were a lot more problems that were coming up at that point. So once you are in the position of acting as the executor, then you do have to continue on doing that. So as I said, in terms of accepting the role, just because someone names you as executor in a will, you personally are not obligated to accept the job. If you didn't even know that you were named as executor, then you might not even feel any kind of a moral obligation, let alone the fact that you do not have a legal obligation to accept the job just because you are named in the role. But if you do accept the role, if you start acting as executor, then you are required to continue on to do the job, and complete the work, unless it comes to a point where you want to be released from that, and the beneficiaries perhaps are willing to release you from that. And in that case, you could decline on it in the first place, or you could ask for the beneficiaries to release you from continuing on to do the work. But once you're starting into the work, you can see how the beneficiaries, those other people, and quite often the person who's named the executor in a family, in a close family situation, the person who's named as the executor is one of the beneficiaries. You can see how the others would want that person to just continue on with doing the job in order to get it done, rather than having someone have to sub in and take over. So if you are named as executor and you don't want to do, you can renounce. So you just say, no, I'm not going to do that, in which case you are not obligated. But once you start into it, you are obligated to continue on. If the beneficiaries are willing to release you from the job, then you may be able to step away, as I said. But if any of those beneficiaries are minors underage, so under 18, or are people where there is a concern that they may not have the mental capacity to give consent, then you're not going to be able to step away that easy. You will have to go before the courts, and you'll have to then deal with, if there are minors particularly, you'll have to deal with the public guardian's office. And if there's somebody who is incapable and there's nobody who can act on their behalf, then you may very well be dealing with the public guardian's office in that case as well. So just be very clear that you want to accept the job and do the job before you do it, because once you start into it, then again you need to continue on. And that's not to say that you're completely operating on your own. You can hire professionals, and when I say hire, you are using the property in the estate to hire those professionals to deal with the estate. So it's not your personal responsibility to hire those professionals when it is dealing with the management of the estate. It could be, if conflicts come up, you might have to hire your own lawyer in order to advise you on a personal level what you've gotten yourself into, or where complications have come up between you and the estate, between you and the beneficiaries. But otherwise, in the normal course of things, you can hire professionals, lawyer, accountant for the taxes if they're a little bit more detailed than usual. Quite often the lawyer's office, trust company will do that if you've hired a trust company. But if they're more complicated, then an accountant might be necessary to bring in to do that work. So you can hire those professionals. Now, if you decide that you don't want to do, if you're going to renounce your job being named as the executor, then it does not eliminate the will. The will still stands in terms of the distribution of the property of the deceased person, but now it's a little bit up in the air who is going to be the executor. If there is not an alternate named in the will, then the close people around the deceased person will be able to apply, and the courts will make a determination of who will be the person who will carry it on. But once again, the whole idea is to get certainty in the management of an estate. So you don't want to have that happen. You want to make sure that everybody is on the same page in terms of the willingness to accept the appointment on the one side of things, and as testator, your clear picture of who is the appropriate person among the people around you to take on the job. So once you're named as the executor, when the person dies, then the will is the document that empowers the executor to act. It is the source of the power of the executor. But others out there in the world need to be certain that the person who is standing there with a document in their hand and saying, I am the executor of this estate, and so I need you, and it's usually a financial institution, I need to take that deposit or that investment under my control so that I can manage it and then distribute out the net cash or the net assets to the beneficiaries. But the financial institution, again, doesn't know whether this person who's in front of them is in fact the properly named executor, because maybe the will that's being held up is not the last will. Maybe there was a subsequent will that superseded this one. Maybe there is an error in the will that causes a problem in the ability of this person to take on the role. Maybe it's a total fraud. So in order to make sure that the person who is purporting to be the executor is in fact able to take control of the assets that is in the control currently of that individual or organization, what they will ask is for a probate application to be completed. And probate is not the proper term, the formal term anymore in the province, but it's generally meant to mean the process of confirming the validity of the will through the court process. So there's a long name to the documents that are involved, but it is filing the will with the court office, filling out the forms that are necessary in order to disclose to the court what the executor has searched for, has confirmed, who the beneficiaries are named in the will. And then as long as the court is comfortable that everything has ticked all the boxes, then the court will say, okay, fine, you can go ahead and act under this will. So the phrase that I have here, 3 phases of probate, it is 3 things in a number of ways. One, we talk about the probate process. So that's one part of it. We also talk about the document that comes back, a probated will, meaning that the will has been submitted to the court has stamped it with their seal or its seal, and that document is referred to as probate or the probated will. And then there's the probate tax. That's the one that people really get concerned about. Probate tax is 1.5% of the value of the property that flows through the estate. So at 1.5%, it should not be a driving force of your consideration of what you're doing with your estate. What you're doing with your estate is making sure that the important people around you are taken care of. And once you have that plan in place and have a will that's been drafted to do that, then if you can cut down on costs that are associated with managing the estate, that's perfectly fine. Just make sure you've got that priority sequence in order. I was actually having a conversation just this morning with someone, and we were talking about probate and possibly getting around probate, and this person's parent was selling a house and moving into a new house, and the question was, should the new house be in the parent's name, or perhaps should this sole child be added on to the ownership of the property right from the start? And there was a concern about probate without really knowing the details about probate. And so once I had mentioned or explained that that's 1.5%, and when you then add on a name to the value or to the ownership of property other than the person who actually owns that property, the parent in this case, then it possibly create some complications. So we talked it through a little bit more. As long as though the plan's in place, and then you make sure that is not going to upset the apple cart, there are some common things you can do to get around the probate tax. So one of those things is you can have a gift during your lifetime. So rather than having all the property go through the formal estate, through the will, you could decide that you're going to give away your 1957 Chevy instead of having it going through your estate, because the probate tax would apply on that, and you know that this child is the one that just loves that car, and so you just as soon give it to them now and see them enjoy it, rather than having it go through the estate, be subject to probate, and then not be enjoyed in that way. Substitute whatever kind of property you might be thinking about rather than a 57 Chevy. I'm not actually a car guy myself. Second thing that you can do, this is not in priority sequence, but second common strategy is to make sure that the beneficiary designations on your registered plans and on your insurance are up to date. So when you name someone as a beneficiary on a life insurance policy and other types of insurance, and on registered plans, so RSPs, RIFs, registered pension plans, tax-free savings accounts, when you name someone as a beneficiary, then the property in that plan goes directly to the person you name as beneficiary. It doesn't go into the estate. So you get around the probate tax in that way. And then the third common strategy is the one that I was referring to, where we can have a property ownership arrangement, joint ownership, which is common. I think that most people on the call here would be familiar with the use of joint ownership between spouses. And really, joint ownership is something that can apply with any number of people. It's just as most common that we see it with spouses. So where you have multiple people owning property, where you hold in joint ownership, then the death of one of those people does not have the interest of that person fall into their estate. The holding of property in joint ownership allows for what's called right of survivorship. So when one of the joint owners dies, the surviving joint owners continue to own the property upon the death of this person. So between spouses, you can see how that makes great sense with your house, for example. Why have the property go down through the estate of a deceased spouse when the only beneficiary, or perhaps the main beneficiary of the estate, particularly for the house, is actually the surviving spouse? So just hold in joint ownership and go over to the surviving joint owner. Now, coming back to the situation that I mentioned, where it is not a spouse situation, but adding on a child, perhaps you can add on anyone, but adding on an adult child into joint ownership on the property You can do that, and it will serve the purpose of avoiding the probate process and the probate tax, but it could cause complications. In this case, if you're not careful how it's documented, in the example that I was giving you there, then mom, who actually owns the property, she will have the continuing ownership of that property, and she's entitled, because she lives in the property, to the principal residence exemption, one of the largest tax benefits we have in our system. Once you add on someone who does not live in that house onto the ownership, you run the risk that now, with two owners on the property, that only the half interest of mom is going to be able to be protected by the principal residence exemption, depending on how that might be interpreted, how they own that property between the two of them. So it's not impossible to have mom continue on to be able to claim the principal residence exemption, so the growth in value of the property will not be subject to tax on the capital gain. But you really do need to have proper documentation of what mom's intention was at the beginning. So for the sake of trying to avoid a 1.5% tax, the probate tax, you could have more complication coming up if you're not careful. So just to raise that as a possibility, one of the common ways that you can get around probate, but something where you really should get some legal and tax advice to make sure that the intention to avoid a relatively small tax doesn't end up with larger concerns coming up in other ways. And as I mentioned that in terms of the principal residence exemption and tax implication, you also have the potential that you expose property to a matrimonial claim or to creditors generally if you're not careful, and just complicating your world. So getting around probate's not a bad idea, as long as it does not cause a problem with the main plan with the estate. So we've got now a person who has decided they're going to accept the job. They're going to do the work to act as the executor. And so what does that job look like as you look out into the future? And I break it down into three categories, three time periods that you look at. You've got the first step of things is that the executor, as I mentioned, is the new legal owner of property. So the executor needs to collect up, identify the property, collect it up, and then bring it under his or her control so that it can be managed, so the administrative activity can take place, large part of it being the filing of taxes, and where there is property that needs to be sold, converted into cash, then that needs to be done. And then once those things are completed, then to distribute out to the beneficiaries what they are entitled to in accordance with the will. So collect, manage, and then distribute. So one of the things you can do if you're the person who is being asked to act as the executor is to ask to see the will. And as the person who is making out the will, the testator, you are not legally obligated to show the will to anyone, but you are asking someone to take on this important role. So it is something to have a discussion about. And when I say take a look at the will, it's not so that you can wordsmith it and question the grammar, although if you see an actual grammar mistake, so be it, bring it up. But what you're looking for as the person who's being asked to act as executor is a picture of what it is you're being asked to do, and if anything surprises you, that is going to put you in a difficult position. For example, let's say that there are 4 children in the family and only 3 of them are named in the will, and there's no reason that you can see why that would be, or maybe you do know the reason, but you, the person who's acting as the executor, are going to be on the hot seat later on to then manage the estate based on these instructions. So is that something that you're comfortable with? At least you can raise it and have a conversation. The whole idea is making sure that you, as the potential executor, understand what the expectations are of the testator, the person who's naming you as the executor, so that you are comfortable with the idea that you're going to be able to carry out the job that you're being asked to do, that you're willing to do. The other thing that can help out is not just having a chance to take a look at the will. As Sean mentioned, there's some documents that are going to come following the call here that you can record information about yourself as testator, so that you give the person who is going to take on this role a starting document of who are the important people around you, which they may know those main people, but there might be more, the important advisors you have, the key property, where it's located, any kind of access information that can be really helpful to an executor to be able to take on that job. Okay, so I mentioned that one of the professionals you might be engaging would be an investment advisor, and certainly your financial advisor, in a broad sense, is probably the professional among lawyer, accountant, and financial advisor. That's probably the person who you have more conversations with on a regular basis. Accountant, you might, if you're a business owner, you might have more regular conversations with an accountant because you have to have your documents prepared and you get your taxes. I would say it's a little bit of a concern if you have a lawyer on speed dial. Most people deal with lawyers when they have unfortunate situations. And I ran law practice where the main activity I was doing was estate planning. And I really enjoyed it. I enjoyed sitting down with people across the kitchen table. I would go see people in their homes. This early on in running the practice. I really enjoyed going and see people in their homes and having these conversations and couching it in terms of really not the morbid aspect of it, but the positive of taking care of the people around you and making sure that you've got control over things to a reasonable extent, but also allowing flexibility. Now, in an estate generally, if everything is to be distributed and not being held on to for any period of time. So if all of the beneficiaries are adults and there's no reason that there's any concern about creditors or wasted money or disability concerns that property has to be managed, or minors, then all the distribution will happen out to those beneficiaries, and there won't really be an investment function. The property will be collected in, it will be kept either in its form or be converted into cash and parked that way, and then eventually transferred on. But where you have a continuing trust for one or more of those people, for the reason that I mentioned, disability, a minor, something of that nature, then that money may very well need to be invested. And in that case, and it might be that it'll be for a few years, it might be for a few decades. So in that case, there definitely is a role for having a financial advisor involved. There is also an important part of that in making out an investment policy statement. How is this property going to be managed? Write it down. How is it going to be managed? Why is it being managed this way? Which is the investment advisor guiding on investment risk related type of concerns. And then once that investment policy statement has been enacted or has been put in place, follow the investment policy statement, not just making it up and then saying, now we're going to do something else entirely, but actually follow the investment policy statement and make sure that it gets verified with lawyer. It doesn't have to be a constant thing, but make sure it gets verified with lawyer that the investment policy statement not only fits in terms of the investment risk that the investment advisor is qualified to advise upon, but that it also comports with the legal duties, the fiduciary duties that the executor has and the ongoing trustee, if this is going to be an ongoing trust. So once you get to the point where you're ready to distribute the property, then you can look at the taxes that have to be resolved before that happens. So again, coming back to our steps that are involved, collecting up the property. In collecting up the property as executor, you need to identify if there are any claims against that property, and that includes the taxes. So make sure that you identify who those claimants might be, those creditors, and that you settle those claims. Make sure that you have filed the income tax returns of the deceased person and that the taxes that to be paid out of that person's property. And then once you have done that, you can distribute out the property to the beneficiaries. So you've paid off all the debts that are involved. If this is a spouse-to-spouse arrangement, that's probably as much as is necessary and you don't really have to go much further. But as you get away from that spouse-to-spouse kind of situation, then as the executor, you want to make sure that you don't get called out on the carpet if you made an error and there are still taxes due, and then you've already distributed the property out to the beneficiaries, because you, as the executor, if you do that, are personally liable potentially for the taxes that are unpaid if you've given out all the property of the estate to the beneficiaries and there are still those taxes due. So something that you can apply for is what's called a clearance certificate. And what that clearance certificate does is it's an application to the Canada Revenue Agency, You fill out the documents, the application form of what you have done to file the taxes, and sometime later, 6 months give or take, the Canada Revenue Agency will confirm that all the taxes have been paid, and then you can pay out to the beneficiaries. And when you're paying out to the beneficiaries, I've got the order of distribution showing here. There are three kinds of beneficiaries. There's different ways you can break these things down, but there's three kinds of beneficiaries generally. There are those who are entitled to bequests, which are certain items, like the silver tea set or that 57 Chevy. So it's an actual item. Secondly, there are legacies, which are dollar amounts that are paid. So $50,000 to the Canadian Cancer Society, $5,000 to each of my grandkids. So those are dollar amounts. Those are legacies. And then after the bequests and the legacies have been paid, then what's left over is called the residue of the estate. And those who are entitled to it in whatever proportions are referred to as the residual beneficiaries. And usually that is the bulk of the estate in most cases. So last thing that I'm going to touch on is compensation. As I said, those of you who have done this before know that there's a lot of work involved with it. If you think that it's free money to be grabbed, then it's certainly not the case. You are going to work for the entitlement of compensation, and it's well earned to receive that. Sometimes you'll hear this phrase, the common percentage. Usually what happens in managing an estate is the executor completes the management of the estate and then proposes to the beneficiaries the amount of compensation that he or she would like to receive. And it would be something logically connected to the amount of activity that's involved. If the beneficiaries, and most specifically the residual beneficiaries, are content with that, then there's no further calculation involved because it's coming out of their distribution out of the estate. But if there is a dispute between them, then the executor may need to apply to the court. And in that case, the case law in behind the calculation of compensation begins with what's called the common percentages, which is roughly 5% of the value of the estate. I won't go through the calculation because it is just a starting point. And then if things are more complicated or less complicated, or that the effort that was involved got a greater result from selling off some of the assets that's beyond expected, then maybe there's more that's entitled or less if it didn't work out all that well. So 5% is pretty much the high watermark, the most that an executor could ever expect to receive. One of the things that you can do is, if you want to, you can name or you can give a gift to the person who is your executor in the will, and that could be a gift in lieu of that person taking compensation. So that's a way that instead of the compensation being a taxable amount, a gift from the estate is non-taxable in that case. Sometimes it will be stated in the will what the executor is entitled to as compensation. So if the executor accepts operating under the will and it says the amount or the percentage calculation, then that's what has to be the amount that the person receives. But whatever happens, as the executor, you need to communicate well with the people who you're acting with as the beneficiaries and keep good records. One, because that's a good way to operate, but also if it comes down to a dispute and you have to prove your entitlement to your compensation, then those good records, those dockets, will definitely support your case for the compensation that you're requesting when it goes before a court officer. So I'm going to stop there, Sean, and shoot it back to you, and we'll see what questions we've got there.
No, that was fantastic, Doug. As you can probably see, my head kept getting closer to the screen because I was very interested in what you were saying, and certainly a lot of it resonates. Now, we did receive quite a few questions, and what I'd like to do, Doug, is maybe a bit of a rapid fire. I'm sure some of these questions you can address, very quickly, and some of them might require a little more of a clarification. But as we were looking through the chat as you were speaking, I was trying to identify, the ones that you did address, and right off the top, you can have more than one executor, you can have co-executors, you can have other executors. It doesn't have to be a single person. But I think the important piece there was, if you are an executor, make sure that your own affairs are taken care of at the same time, so that there's no wastage or problems trying to resolve the estate. You did address how to find someone to serve as executor and what type of criteria. Ultimately, would it be safe to assume, Doug, that in most cases it's either the spouse or the children that serve as executor, right?
Yeah, unless there's some reason that there's concern about their capacity or just the stress it might put on them. But otherwise, yeah, you're looking internally first. Yeah.
Right. And we do have members that, do not reside in the province of Ontario. So do the rules differ significantly in other provinces? And maybe that's more of a broad question, but I do believe they're governed provincially, correct?
Yeah, so estate law is provincial responsibility, and so yeah, the rules do differ from province to province, but on that principles of family first as naming executors, there's nothing legal about that. This is a practical matter, so that would apply in all the provinces. One of the things does come up, and this isn't exactly what you're touching on there, but what about naming someone as your executor who's in another province? That's something, as a matter of distance, might make things complicated, but there's no reason why you couldn't do that. Where you do get into a little bit more of a problem is if you name someone who's outside the country, then you run the risk that in order for that person, even your own child, in order for that person to act as executor of the estate, a bond may have to be posted. So you have to pay to a bonding company, pay for a bond so that if the executor of the estate absconds with the assets, then there's a financial fallback to protect the estate. So think about that, again, conversation with your lawyer about naming someone outside the country, whether a bonding requirement might apply to that would add cost to that person acting as executor.
Yeah. And a couple of questions that came in around this topic, which we've addressed, but I just want maybe you to reinstate it or reinforce it, is the executor can also be a beneficiary.
Yes, yeah, I mean that's pretty common. I mean, there's a built-in conflict to that, but yeah, that's pretty common to have that happen.
For sure, for sure. Another question that did come in was related to costs. So, if you're managing the estate, you have to hire an accounting firm or you have to seek additional advice or counsel. Who pays for these costs?
If it is directly related to the estate management, so it is arising because the assets of the deceased person or the actions of the deceased person or characteristics of the deceased person have caused a confusion that needs to be resolved, then definitely that's something which is the cost of the estate. If it is the person who is named as the executor who is concerned about his or her own liability, perhaps related to acting as executor, then that is the executor's responsibility and the executor's cost on the personal level to then hire professionals if that person wants to do that. In pursuing that, first question to the lawyer that you would be talking to would be, what category does this fall into before we get past the first 5 minutes, and then I'll decide how it is that I go about pursuing this.
Yeah, definitely. So, and I apologize, I'm just trying to get through as many questions as we can.
I'm going to jump back when I see one of them right near the top.
For sure.
I want to touch on this question. So the question is basically, do you name two people to act as one or the other, or do you name them to act together? So I want to touch on this issue of naming people to act in either the capacity of executor or as an attorney under powers of attorney. That one of the key distinctions that there are about the way that these things operate is you can have one and then the other. It just depends on how you feel about it, whether you're comfortable with one person acting or if you want multiples acting at the same time. The most efficient committee is a committee of one. Also, or on the other side of that is you have more oversight when you've got two or three perhaps, but it can get really unruly the more people you get involved in that. But the way that they operate when they're operating together is either acting what's called jointly, no surprise on that word, but jointly, or joint and several. And what that means is jointly, they all have to be in 100% agreement on everything. Smaller things, perhaps they can instruct on without having the others involved, but otherwise they all have to be in complete agreement. Whereas when it's joint and several, which is actually probably the more common, then any one of the executors can act on behalf of the estate to get things done. Where it's the big stuff, then nobody is going to allow for the sale of the property on the other side of a transaction, the sale of real estate, and accept it from one executor when there's three of them. But technically, under a joint and several, any one of them can bind the estate. So key distinction between joint and several.
There's another, and that's very interesting because I know people like to have multiple executors or to be named, especially if I know it happened with a family friend of ours who had a few children named as executors, co-executors, and they weren't they didn't get along the best of times, so it posed certain challenges, definitely. Another question that I thought is interesting here is, should an executor obtain some form of liability insurance? Because there is a lot of risk associated with being an executor. So what is your thoughts on that, Doug?
Yeah, I won't say so much as a should question, but I would say that could you obtain that insurance? Yes, you could. There is actually executor's insurance, and when you get that executor's insurance, you as the executor, when I talked about the probate process, going through the court confirmation process, that probate process, everyone looks at it from the standpoint of, oh, it's going to have cost, hassle, all of those things. But on the executor side, the person who's being named as the executor, if you have a probated will and you are operating under the probated will, as long as you are doing everything in a bona fides way, that you are acting under that will and not going outside the lines, then you are protected from personal liability. If you skip over getting the will probated and someone decides to come after you as executor of the estate, you could find yourself with higher liability in that situation. So directors insurance, this isn't directors, but those types of insurance that are available for people in acting in a personal capacity, like acting as a fiduciary, those are the kinds of protections that an executor definitely should look into, and it is available to get executor's insurance.
Thank you, Doug. We have many more questions, and unfortunately, we won't be able to get to them all. But I did want to perhaps just quickly summarize some of the items that we talked about today. The executor themselves, if you're named executor, you should have your own estate planning in place to mitigate any risks. We talked about co-executor in challenges of having multiple executors. The legal nature of an executor I thought was very interesting, because you are bound by certain duties and the timing around fulfilling some of those terms of the will. The executor has to file with the court, has to manage the assets, has to collect the information, has to distribute it. And it does sound like it could be a very involved process. So certainly you want to have an executor who can at least afford the time and the attention required to execute the will or the wishes in the will. We talked a little bit about joint ownership and ways to try to bypass probate, avoid probate. I wouldn't say avoid, but opportunities where you could try and reduce the estate tax on that side. And compensation, I thought that was very interesting, because I don't think a lot of folks take that into consideration. What is the impact? How do you calculate it? What kind of challenges it can possess? So certainly maybe having that discussion with the individual who's preparing the will, it might be something to do beforehand, and have that indicated in the will in terms of compensation for the executor. Doug, I wanted to thank you, and certainly all of the folks watching. It was certainly a lot of information. We will have more information and more sessions like these. If you have additional questions, please reach out at wealth@alterna.ca. We will endeavor to try and have more of these sessions. And if you have any suggestions, feel free to drop us a line at that very email address. We would like to make these webinars something that is more important and relevant to you, and certainly, want to make sure that you're getting the most out of this time commitment from your day. With that, this session recording will be made available, and we will have additional supplementary information, which you can certainly take away and review and help in the preparation as an executor of the estate. Thank you, Doug, and thank you all for joining. This concludes our webinar.
Thanks, Sean.
Thank you.
Thanks, everyone.